Morning, everybody. How are you? You can use your thumbs up to say you're okay, or you can use your thumbs down to say you're not okay. So you're all good, yeah? Is everybody excited to be here through this week of learning? Yeah? Have you all been in other sessions? You all been in other sessions, yeah? Fantastic. Mind you, I like to have a bit of dialogue whenever I do things like this. So please don't be afraid to shout out. Okay? Is that a deal? You'll shout out, yeah?
Yes, absolutely.
Fantastic. That's what I like to hear. It makes it a little bit more enjoyable, doesn't it? Okay, so we're going to go straight into whistleblowing. And the first thing I'm going to ask you to shout out about is what you think whistleblowing is. So what do you think whistleblowing is? Just shout it out.
Concerning the public interest.
Now, concerning the public interest, has somebody been reading policies? You've got a concern in the public interest. Anything else? Anything else? Huh?
When you think someone that you work with is possibly doing something wrong?
Yeah, it could be. Yeah, it could be that. There's a whole process around it. And to be fair, I mean, I'm looking at this from a health and social care perspective, but most industries do have a whistleblowing policy. You can see it in the airline industry, particularly around safety. The water companies, they've recently had a whistleblowing against them because they were dumping lots and lots of sewage into the rivers. Train industry, where the railways, any kind of industry can have a certain level of a whistleblowing policy or a process. In terms of health and social care, whistleblowing happens when somebody who works for a provider raises a concern that bad things are going on, basically, like malpractice or like risks that can harm people or possible illegal actions. If you think about illegal actions, you think about when people dump sewage, that's an illegal action. Okay. So who do we think can raise a concern? Are there specific people that can raise concerns? Or do you think just anybody can do it?
Anybody.
Yeah, absolutely. Yeah. If you do have a whistleblower, not all companies will have a whistleblowing policy, but they will have some level of process where you refer to with your concerns. But anybody, your whistle policies should encourage everyone to raise a concern. And they could do that openly. For example, with a line manager. And if you do raise it with the line manager, your line manager is expected to handle this and handle these concerns sensitively and appropriately. But we all don't want to do that. You know, some people feel a bit nervous about raising these kind of things to anybody within the industry that's responsible for the wrongdoing. So you do have other bodies. You do have, then they're called prescribed people or prescribed bodies. So you can raise that issue through your organization if you feel comfortable to do so, or you can raise it through a prescribed person or a prescribed body. Now, in my case, the prescribed body is the NMC, which is the Nursing and Midwifery Council. They are legally, under law, a prescribed body. That's the other thing you have to think about, is where you raise that concern to a prescribed body, that prescribed body has to be recognised as that in law. So you can't just raise it to anybody. But you'll find most regular, if we're all like qualified staff here, nurses, doctors, they'll all have prescribed bodies that oversee them, and OTs, social workers. But the thing about whistleblowing, it is there to protect the public. It is there to protect patients as well. And it's also there to protect your colleagues as well. And it does support the workplace to be open and transparent and accountable. Because the workplace has got to have those policies and those, particularly, I talk about the NHS, we have freedom to speak up guardians, and we have lines where we can be open and make the organisation accountable for any wrongdoing that's happening. And then we can make the organisation learn from those things. We've seen stuff like that in the Francis report, Berwick report. So many reports have come out where they initially started with one person saying, this is happening here. So it does make the organisation open, transparent and accountable. And it can help prevent future concerns. And it certainly does protect the public. So what's the law around this? Well, legally, whistleblowing is actually in law called making a disclosure in the public interest. That's what it'll be defined to in law. But don't worry about that. That's if you're a lawyer and stuff like that, and you're going to court, you won't be calling it a whistleblowing. You'll be called they are making a disclosure in the public interest. So that's what the legal term is for it. This means it must affect others. There is a criteria for it to be a whistleblowing. So it must affect others. For example, the public. By law, most people are protected if they do make what is known as a qualifying disclosure, which I'll talk about in a minute. And that includes workers, employees, agency workers, apprentices, practitioners in the NHS, any student nurses, student midwives, student whatever, professional student social workers, police officers, people who are known as office holders. So they're people that hold office in governmental departments. And it could be self-employed doctors, dentists, where you go to have your eyes tested, because they all work as part of the NHS. Even though they're private, they still work with the NHS. Protection for people under whistleblowing law starts from the very beginning of your employment. So day one, you are protected under law. Okay. Also, if you no longer work for that employer and you're disclosing something about that employer, you are still protected under law. You are protected against unfair dismissal and you're protected against detriment. But if you're going to make a claim, you're going to make a disclosure, it must be a qualifying disclosure, which we'll talk about in a minute. And you must follow the correct process because there is a process to it. And if you are going to take the organisation to an employment tribunal, you had to be dismissed or suffered some level of detriment as a result of making that disclosure. Does that make sense? See, when I say things, does that make sense? You stick your thumb up or you stick your thumb down. So does that make sense? Yeah. So it makes sense, yeah? If it doesn't make sense, just shout out, okay? So you are protected and you can't do it. So this is what you can whistleblow about. So these are like your qualifying disclosure. You can see there are 5 of them there, which is criminal offence, breach of legal obligation, a miscarriage of justice, someone's health and safety, and damage in the environment. Now, a criminal offence, that could be anything, like an employer tried to bribe somebody to get a contract. So that would be a criminal offence because they're not supposed to do that. If it's a breach of legal obligation, that could be an employer has neglected their duties, say towards children in a care home or towards patients on the ward. So there's multiple people being affected by that because the organisation has neglected their duty of care. So that's a breach of their legal obligation. If you have a miscarriage of justice, that could be a number of things, like a member of staff being dismissed for something that turned out to be, say, like a computer error, or a process that's not been followed correctly in their policies. So somebody has targeted an employee and it got them dismissed, or targeted a number of employees, or built that culture up within that organisation, and employees have been dismissed as a result of that. Okay. For anything around health and safety, I think there was a recent case where staff were forced to serve contaminated food in a nursing home somewhere. So that would be that breach of health and safety. And the other one is what it says on the tin, damaging the environment. Whereas, like I said earlier, like water companies have been polluting local rivers. But you can also whistleblow on someone who has been trying to cover this up as well. So it's not just the act, it's the cover up. And what tends to happen is the cover up becomes the worse thing than the actual act itself. So anybody who's trying to cover that up, if the organisation is trying to cover it up, you can whistleblow on that as well. You can make any kind of disclosure about an issue that's happened at any time, okay, that you've witnessed or you are aware of. And this also includes if it's likely to happen in the future. If the situation is such within an organisation that X, Y, and Z is going to happen and that's going to affect lots of people, then you can make that disclosure. It can also be about something that's taken place overseas. Now, I can't remember exactly if this was a whistleblowing, but there was an issue with Oxfam, and I believe they were in Thailand or somewhere, and they were involved in visiting sex trades. And a lot of these people who were in that sex trade were underage, and that I believe somebody reported that, and all of those people were subsequently prosecuted. So they were doing that in Thailand, although they were British citizens, so they can do it if you're abroad as well. So you will be protected if your disclosure fits into one of these 5 categories. And remember, it has to be in the public interest. Okay. Any questions so far? No questions. I must be doing pretty good then if there's no questions. So you all understand all of that. So you understand what a disclosure is. Yeah, cool. So you got those 5 areas there. And as you can see, something you think, oh, breach of legal obligation or a miscarriage of justice. You have to fit it to what your organisation is, like that bribe as well. Not necessarily a miscarriage of justice that somebody's been thrown in prison for years and years and years. Now, you will not be protected making a qualifying disclosure if you commit an offence or breach a legal profession privilege. Now, the first one is, for example, if you were disclosed, you're making a qualified disclosure and you were looking for evidence and you stole files, or if you hacked into a computer system to get that evidence, that is committing a criminal offence. So the whistleblowing will not protect you. I think that happened to that chap who spent years in an embassy because he committed an offence, so therefore he's not covered under the whistleblowing legal framework. The other part refers more to solicitors, lawyers, and legal advisors. So if a legal advisor, you're disclosing that to a legal advisor, and the legal advisor discloses that to somebody else, that is a breach of confidentiality. So that legal advisor would not be protected under whistleblowing law. Whereas if he doesn't disclose it, he is protected or she is protected under whistleblowing law. So they're the 2 examples where you will not be protected. And that is about a criminal offence and confidentiality. If your concern is a personal problem and not in the public interest, then it will not be covered by whistleblowing. That should be done through different pathways, through your internal pathways in your organisation. And for all the managers here, it is something that you shouldn't ignore, because there is a personal problem that the person feels so strongly about, feels concerned that they were looking to make a qualifying disclosure. There is something going on there. So I advise managers just to have that chat with them. But if it's a personal problem that's not in the public interest, then it's not covered by whistleblowing. Okay. So how do you make a disclosure? First of all, you must make sure your disclosure is made with reasonable belief. So you must have a reasonable belief that the wrongdoing is taking place. It has to be a qualifying disclosure, as we just said, and it has to be in the public interests. Okay. When making a disclosure, it's good practice to consider there's a list. This list here, your employer, your legal advisor, your government minister, prescribed personal body, or other personal body. So you should really work your way down that list. So it's good practice to consider that list in order. Okay. However, as I said earlier, there are times when you don't want to go to your employer first. If you go further down the list, you may want to meet more than one requirement. The exception to that is the legal advisor. Your legal advisor, you could meet at any point on that. So a good example would be if you had a health and safety concern and you spoke to your employer, but nothing happened. Then you could make the same disclosure to the health and safety executive, who are a prescribed body. Okay. So you don't speak to the legal advisor, you don't have to speak to your government minister, you could speak to your prescribed person or body. You may have to give the reason for why you made that disclosure if the case reached the employment tribunal. But if you've got good rationale for doing it, then it's not a problem. And it's like when we document, we have to document everything. Yeah. You can skip the people on the list if they're not appropriate and consider who's the most appropriate first. Your employer, you should make that disclosure to your employer first. This will allow the concern to be dealt with faster and by the best person. Make it very clear that you are making a disclosure, okay? Follow your whistleblowing policy or process and write a letter to the most appropriate person in your organization. You must reasonably believe that the organization is responsible for the wrongdoing. If you go to your legal advisor, your disclosure is protected if you make it to a legal advisor while you are getting legal advice. The legal advisor will not be protected if they make that disclosure about something they've learned from you. Okay? Government ministers, you are protected to disclose to any government minister. For example, we work in the NHS, so therefore we are a non-departmental public body, so we can disclose to any minister within the Department of Health and Social Care. Okay, so we can make that disclosure. Or you can go to your prescribed body, which could be the Health and Safety Executive. It could be a commissioner, a regulator, like the CQC, or it could be your professional body, which is like the NMC, GMC, the College of Occupational Therapists, those kind of things. But remember, put it in writing, include the background and the reason why you have already raised this concern and their response. Any relevant dates, and include any relevant evidence such as documents and photographs, etc. But remain in that legal framework, okay? Don't go hacking into computer systems to get that. So this is what whistleblowing is as to the NMC, which is my governing body. This is how they define it on their site. It's basically what I've just said. Okay. Any questions so far? So we've already got half an hour to do this, and realistically, we could spend a couple of hours doing each of these subjects. We could do a whole morning on all of these, myself and Victoria. But we only have half an hour, unfortunately. So how do they respond to the concern? What is the right process? First of all, it has to be handled fairly and consistently. They have to follow the process that you have and keep the identity of the whistleblower confidential. They can't put your name splattered all over the place. If you have a whistleblowing policy, then it's easy. Follow your policy. Make sure your staff know about your policy. Make sure your line manager and HR are up to date with the latest procedures, and review the process regularly to see if it's fit for purpose. If you don't have one, develop one. This will allow you to recognise and respond to the concerns fairly and consistently. So if there's not one there, develop one. A lot of the times, whistleblowing seems to step over the grievance, and there are grounds when a grievance comes out that it can actually be a whistleblowing concern as well. But if it is a grievance, just follow the correct grievance process. But if you feel you have reasonable concern that this may also be a whistleblowing concern, then check. Okay, you can always contact your prescribed body, or you can always contact your HR, you can contact anybody around there and ask them, would this be a whistleblowing? And they'll have to keep that confidential, okay? Because some grievances could be a whistleblowing, particularly in relation to a culture, and there's more than one person being hurt in that, okay? If you're doing both, follow both processes and confirm all of this in writing so nobody makes no mistakes about it. If it's a personal problem, the concern may be related to a personal issue and does not fall within whistleblowing law. As I said, don't ignore it. Try and find a way to resolve it. Take it seriously. Follow your policy. Listen to the concern. Consider the evidence that may be available to support the concern. Reassure the person and keep their identity confidential, and they will not suffer any detriment. Try and answer the questions and explain why you can't answer those questions. Keep them informed. Give them feedback post-investigation, and make sure all of your managers are trained. If you do cause detriment, then you could be in big trouble. Your organisation could be in serious trouble. Now, causing detriment includes, but not restricted to, treating the person worse than they were treated before, having their situation made worse, reducing their hours, causing them to experience bullying and or harassment, and turning down training requests with no good reason. And there are two areas there which detriment sits under. Well, one area that is vicarious liability. So if that somebody is bullied or harassed because they made a disclosure, this will be considered detriment, and this can be carried out by an employer, a person who is carrying out the bullying, or both. Okay. That could make the person who's carrying out the actions responsible as much as the organisation. Okay. Or even if it's somebody outside the organisation, say a family member of the employer or a contractor, they can also be considered causing detriment. A lot of firms will use NDAs, which is your non-disclosures. In terms of whistleblowing, NDAs are meaningless. They cannot stop somebody from whistleblowing. Okay. So just a quick overview, and then I'll hand over to Victoria. Right, hopefully you all understand what whistleblowing is. Is that a thumbs up? Do you understand what whistleblowing is on this whistle-stop tour of it? Yes? Great. And as I said earlier, one of the areas where people may misinterpret whistleblowing is grievance and complaints. If there's a problem with your employer, it usually falls into one or two categories, either a grievance or a disciplinary. A grievance is where you raise concerns or problems or complaints with your employer. Disciplinary is when an employer has concerns about you. Okay? For the reasons in this presentation, so if you think about what whistleblowing is and how we report it, the whistleblower should not be expected to prove the malpractice. Okay? Unlike the grievance, you have to gather evidence on both sides, complaints to gather evidence for it. In the whistleblower should not be expected to gather that evidence themselves. They are expressing the concern. They are the messenger, and they're raising the concern to others who should be addressing it. As I say, that's very different from a complaint or grievance. When someone complains or raises a grievance, they are saying they have been personally treated poorly, or there is concern about their conduct. So, for your disclosure to be protected, just going to recap, you must also be reasonably concerned about disclosing the information in the public interest. It means your concern must affect people and not just you. And you are not the only person impacted by it. For example, bullying and harassment, although bullying and harassment could be a culture and it could be more than one person. So therefore, it is potentially a whistleblowing, because that could have an impact on public safety or on patient care, and therefore becomes in the public interest. Any questions? No questions. Wow. Thank you. So is that all okay? I know it's a really, really quick whistle. It's only about half an hour. But did you get some kind of understanding to what whistleblowing is and the process around whistleblowing? As I say, we could talk about this for hours, because it is that massive a subject and you can go really into depth with it. But we've only got half an hour, so we gave you a really brief skim over the top. And I'll hand it over now to Victoria to go into the PiPoT.
Thanks, Steve. So I'm just going to take control. So hello, everyone. For those of you that don't know me, my name's Victoria. I'm the name nurse for safeguarding adults at Northampton General Hospital. So leading on from Steve's presentation there on whistleblowing, we're now going to speak about PiPoT, which stands for Persons in Position of Trust. So does anyone have any idea of what PiPoT means, what it relates to? You can shout out, or maybe that you don't know anything, which is fine.
Isn't it when somebody that's in a position of trust, so say a carer or a relative, abuses that position by doing something a bit like a financial abuse, but that person works for an authority?
Yep. It can be that to an extent. Yeah, thank you, Gail. Thank you. Any other thoughts on what PiPoT is or why we have this process? That's absolutely fine. Hopefully within the next half an hour you'll know. Oh, someone's put here, I took it to mean someone in authority, such as a teacher, social worker, but I need to learn more. That's absolutely fine. That's why you're here. Thank you. So an overview of what PiPoT is. So it's a process, it's a framework, it is a requirement under the Care Act 2014, and it's within the statutory guidance that all Safeguarding Adults Board have this process embedded and in place. The protocol that I'm going to speak about today should be read in conjunction with other safeguarding processes and policies, which can all be found on NSAB's website. And within Northamptonshire at present, our policy is currently being revised, and the policy is the protocol for responding to concerns about a person in a position of trust. So before we progress on how we report and why we report, we need to understand what constitutes a PiPoT referral and how that can also be maybe a safeguarding concern. So what actually constitutes a PiPoT? So a person in a position of trust needs to be working with adults with care and support needs, and these can be voluntary sector as well. So it's not just paid work, but it's paid and unpaid. And the person needs to have been accused of abuse or neglect of a child in their personal life, bringing into question their ability to perform their professional role, e.g. their own children, maybe under a child protection order, has been accused of abusing and neglecting an adult family member in their own personal life, bringing into question their ability to perform their professional role, has been accused of GBH towards another, bringing into question their ability to perform their professional role, or has behaved in a way that puts into question their ability to provide a service to an adult with care and support needs, which must be reviewed. So when we're looking at the concerns that can be raised, they can be current concerns or they can also be historical concerns. So it's not just about people's practice, it's also about people's personal life that can impact their ability to be able to care for adults with care and support needs. How that correlates with a safeguarding concern, when we're looking at what would constitute a safeguarding adult concern, is that when a person in a position of trust working with adults in care and support needs, again, whether it's unpaid or paid, has abused or neglected an adult with care and support needs, has behaved in a way that has harmed or may have harmed an adult with care and support needs, possibly committed a criminal offence against or related to an adult with care and support needs, has behaved towards an adult at risk in a way that indicates that she or he is unsuitable to work with adults, or any sexual relationship that develops between adults where one is in a position of trust or authority in comparison to the other. So it may be that these two processes run alongside each other, but I think it's really important to understand what would constitute a PiPoT. So apologies, I know that this is quite a confusing chart, but once a concern has been raised or there's been an allegation made against a staff member, PiPoT is not to replace your own internal processes. So every organisation should have their own internal processes and procedures that are followed once an allegation against a staff member or a concern has been raised. It's the organisation's responsibility to understand about that individual, whether they work anywhere else. So that maybe that they're undertaking voluntary work in a different sector, or it may be that they have paid work in other organisations. If that is the case, then they would need to consider reporting that via PiPoT. I also think it's really important to highlight that there are lots of different processes that can go and coincide with one another. You need to consider whether a police referral, for example, needs to be made if there's been a criminal offence. Again, they will do their own investigation in respect to the police. We also need to consider the designated officer, so previously known as LADO, if it affects children. One's regulatory body, so I know we've got a variety of professionals here today, but it may be that it is you're registered by the NMC, GMC, Social Work England, whoever your regulatory body of that professional is, you need to consider whether a referral needs to go to them. You may need to consider a referral to the DBS or the CQC. And like I said, and just spoken about, it may also need a safeguarding adult concern to be raised to the local authority. So one thing to take from today, the PiPoT process is not to duplicate any other work that's going on. You still need to undertake that investigation internally. So when we're thinking about how a concern may be raised and identified as a PiPoT, it could be a whistleblowing disclosure, so such as Steve has just touched on there. It could be that there's a safeguarding adults inquiry that's been undertaken and it highlights that there's somebody involved that is working with adults at risk. Likewise, with a safeguarding children's investigation, it could be that a complaint's come through, and once that complaint's been understood, it relates to somebody working within a PiPoT. Reports from members of the public, providers alerting commissioners of services, and any other sort of disclosure. So as Steve has said as well, it could come from any type of different disclosure, but it needs to be taken seriously. I think with all concerns that are raised about professionals, you do have to be really cautious. You need to be very monitored on the information that you share, and you have to be very measured in your response. But PiPoT should be disclosed if there are any concerns that need to be raised to the local authority. So the criteria for a PiPoT to be raised, so you need to reach one of these of the following criteria. So the PiPoT's own work or voluntary activity with adults or children has highlighted that they have neglected one's care and support needs. As I've said earlier, it can relate to someone's life outside of work, so their personal circumstances may have led them to be in a situation that then starts to question whether that person within their own professional capacity can perform and work with adults with care and support needs. But it may also be a concern that's happened within the organisation, which may question one's ability to be able to work with adults with care and support needs. And the person needs to have either behaved in a way that has harmed or may have harmed an adult with care and support needs, possibly committed a criminal offence against or related to an adult with care and support needs, otherwise behave towards an adult with care and support needs in a way that indicates that she or he is unsuitable to work with adults with care and support needs, behaved in a way that's harmed children or may have harmed children, which means their ability to provide a service to adults must be reviewed. So just because it doesn't relate to an adult, we would still need to raise it if they predominantly work with adults. May be subject to abuse themselves, which means their ability to provide a service to adults with care and support needs must be reviewed, and behaved in a way which questions their ability to provide a service to an adult with care and support needs. For example, if they've had a criminal offence of a GBH, whether or not it is against an adult with care and support needs or not, it's just questioning their ability to care for those who do have care and support needs. Any questions before I move on? Feel free to shout out if you have any questions as we go along. So once it's been decided that somebody has met the criteria for a PiPoT to be raised, what you need to do at that time is share the information with that individual unless you feel that it could put another person themselves in danger or put further their risk. But we should be really open and transparent and saying that we've got this concern and we're going to raise it. Offered a right to reply against the allegation or concern raised against them. Again, we have to be really cautious about the concerns that we see. Within my practice and within my role, sometimes I see allegations that come in against staff, and actually they could be from a malicious perspective. So we need to be really measured in our response. So we need to be giving people the opportunity to say from their perspective what's happened. It may not have happened at all. But it's not just to do things to people and put these measures in place. Given the opportunity to tell their employer, student body or organisation themselves, unless the immediacy and nature of the risk does not allow for this. So people should always be given the opportunity to report to their own organisation, and their organisation at that point can then enact any processes that they feel are appropriate. And we would question if somebody hasn't told their organisation and had the opportunity to, that would be part of your risk assessment that you would undertake at that time as to why they haven't shared that themselves, and advise what information will be shared about them, how the information will be shared and with whom. So it's just again about being really transparent with that individual. This is our process, this is why we're raising the concern. I'm not going to teach you to suck eggs when we're thinking about information sharing. Seeking consent from the individual should always be the first option. So we need to be having that conversation with somebody, like I've already said. This is the concern that we've had raised with us. What are your thoughts? But actually our process is that we now have to alert the PiPoT process and alert the local authority. Unless, like I've already said, it would put that adult or another adult or a child in danger, and increase the risk to them. However, you may have a situation where you ask for consent and you haven't gained that consent. It's really important to know that we have a lawful duty to report any concerns, even if that person doesn't consent to it in the interest of the public. But the first thing that you should be doing is alerting that individual that there has been a concern raised and you will be reporting it. And I think as well, when we're thinking about PiPoT, people sometimes see it as a pointing fingers exercise. However, I've seen PiPoT be used in a very supportive measure. So we've had an incident externally that was raised by the police, that shared with the local authority, who shared that with myself about an employee here in the organisation. But actually the purpose of sharing that information with us as an organisation is to make sure that we are aware of this individual, that they're struggling in the community because they were currently off work, and making sure that they've got all the right processes and support mechanisms in place to support them through their difficult time in their life. So it's not just about putting sanctions on people and saying that you can't work. Actually can be used in a really positive way to make sure that that colleagues within other organisations know that somebody that's working for them is in this situation at a current time and they need support. Changus, have you got your hand up?
Yeah, that's fine. I think, Victoria, you already mentioned that. It is many referrals that I have seen, there don't appear to be, the PiPoT hasn't been informed that
Right.
that referral has been made. And I think something that we really need to be emphasizing on, that once the referral is made, that the PiPoT that is shared where appropriate. It could be that a decision can be made that they're not to, but that is outlined. Yeah, thank you. Thank you for clarifying that. Yeah.
Yeah, thank you, Changus. Yeah, the first port of call obviously is to gain consent from that person to share with them, because if something was happening about that individual, they should be involved in that process. I think as well, just doing a bit of an oversight of the information sharing as well from a PiPoT perspective. So when you share that information with the local authority, with the PiPoT lead there, they would look at that information, they would undertake their own risk assessment and actually understand whether they need to share that and if it's appropriate to share with the organisation that's working with that individual, or either on a voluntary or a paid basis. So all the information that is shared regarding PiPoT, even if it goes through that PiPoT process, it may be that actually that doesn't need to be shared with another organisation. But it's really important that that person knows about the outcome of that, and the outcome of your internal investigation as well. Again, not to take away from that as well. Just touching on record keeping, again, I know we're all professionals, so we know about the importance of record keeping, but the purpose is to prevent unnecessary reinvestigation if an allegation resurfaces after a period of time. So different people work within different areas. It may be that something's come to light and it hasn't been reported, or somebody is concerned that it may not have been reported, because again, we can raise our concerns about historical issues, but it may be that actually this has been dealt with previously. So it's really important that everyone keeps their own record keeping as to the conversations that they've had regarding the allegation and the process that they've followed, just to not even is to consider that individual and the stress that it may cause them, and the trauma as well. If it's been a traumatic time for them, bringing it back to the service can be really difficult for them. It enables patterns of behaviour which may pose a risk to adults with care and support needs to be identified. So again, really important to understand what's going on, where it's going on. Is there a cultural issue? Is there an institutional abuse going on? What is going on? So it paints a bigger picture that may be happening at that time. And it's so important to share that information for that reason. And it also ensures the Safeguarding Adults Board with the adults with care and support needs are protected from harm. Records of actions taken to investigate the PiPoT without substance must be retained to build up history. So it may be that you've got a snippet of information that you shared with somebody, and actually more information then comes to light. So it may be at that time that little snippet of information isn't shared with another organisation because it doesn't feel that it's necessary and it's appropriate to do so. But as more information comes in and is shared, it may be that it forms that picture of what's going on, and actually it does need to be shared and a risk assessment needs to be undertaken. All the information that should be recording regarding the concern and regarding the PiPoT is fair, accurate and balanced. And a recording template is available on the PiPoT toolkit that NSAB have on their website, that's easily found within the resources and the policies and processes. but it's not an absolute need to have that. It's just a really good foolproof guide to make sure that you've covered everything and make sure that everything that needs to be considered has been, and the documentation is there. So that's a really useful tool for colleagues to use. There may be an incident where there's an allegation regarding a potential PiPoT who doesn't work within Northamptonshire, or it may be that they have other work within other areas. So from a health perspective, for example, we sometimes have agency workers who come and work for us, and I'm sure it's the same everywhere. That individual may also work in other places and may work outside of Northamptonshire. Northamptonshire won't have the information that is required to share with the organisation if they're outside of Northampton. So what you need to do as professionals is familiarise yourself with the relevant Safeguarding Adult Board and their guidance and the process that they have. It should be very similar because it's a statutory responsibility, but just to make sure that you're putting it into the right person, because like I said, if they are working outside of Northamptonshire, colleagues working within PiPoT aren't going to have the relevant contact, so it's not going to go anywhere. Just touching on responsibilities where there are potential risks to children. So we also have the designated officer, previously known as LADO, which is headed from the Safeguarding Children's Board within Northamptonshire. So where a person's conduct towards an adult may impact their ability to work with or continue to work with children, this must be referred to the LADO. Where concerns have been identified about their practice and they are a parent or a carer for a child, then consideration by the data controller should be given as to whether a referral to children's services is also required. So again, it's all about think family. Let's think about the children that could be involved within this environment, and it may also need a children's safeguarding referral to be made on behalf of those children to protect them. When we're thinking about whether we need to raise a referral to the designated officer, there needs to be an allegation that a person who works with children has behaved in a way that has harmed a child or may have harmed a child, possibly committed a criminal offence against or related to a child, behaved towards a child or children in a way that indicates they pose a risk or harm to children, and behaved or may have behaved in a way that indicates that they may not be suitable to work with children. So very similar to the PiPoT process with adults, but it's just referring to children. So just to think about good practice and thinking about your own organisations, because like I said, we work for different organisations. Does your organisation have an adult PiPoT lead? If you're not sure who that adult PiPoT lead is, it may be that you have a conversation with whoever is your manager. Often they sit within the safeguarding team, but it's really important that an organisation does have an adult PiPoT lead. Again, to have conversations between organisations to make the process as seamless as possible, we need to be having contacts. Does your organisation have a PiPoT system to record concerns, the steps taken, the decision made, the actions or no action, and the basis of taking this position? It may be that you're put your concern to your PiPoT lead and they don't feel at that time that it warrants a referral to PiPoT. Just as important as it is to document all the steps that you have taken to refer to PiPoT, it's also equally important to record as to why you think it's not appropriate at that time to share with PiPoT. Again, it helps build that picture. So really important about your documentation. Does the recording mechanism support defensible decision making? Again, why haven't you raised a PiPoT, or why have you? It needs to be defensible. How is your PiPoT information held? So is it held securely? Is it held within a centralised place that is easily accessible to the people that require it, but not easily accessible to those that don't? Does your organisation consider how support is offered to a person subject to an alleged PiPoT concern? So again, thinking about how difficult it often is if a PiPoT is raised about an individual and a member of our staff, how are you going to support them through that process? It may be there's also an ongoing investigation with HR or a safeguarding concern that's also ongoing. And what mechanisms and support does your organisation have to make sure that person feels supported in the best way possible? And that may not be that it's the PiPoT lead, it could be somebody pastorally that isn't involved with that individual, but just making sure and being really aware of the stress and the difficult situation that people find themselves in if they are referred to PiPoT. Does your organisation establish sources of advice? So it may be that if there's a concern that maybe needs legal advice, do you have different avenues to contact support so you're not making that decision on your own? Just as it is with safeguarding, it's so important that people share information, and other people may hold information about somebody. So for example, if it's a police investigation, we may need to understand a little bit more of information on the risks that person poses to make our decision whether we're going to refer or not refer to PiPoT. So it's just about having those contacts, which your PiPoT lead should have, and ensure you have all the relevant adult PiPoT data to prepare for your NSAB assurance report, because they will be asking for that. So in summary, every organisation has a responsibility to investigate concerns following any allegation. Other referrals maybe need to be made following a concern. Something that I really should stress, and I think is so important, is the importance of people understanding other people's roles and responsibilities within their professional or non-professional life. If no exploration is had at that time regarding that individual, if they're working anywhere else, if they are part of any other group, so it could be that somebody works professionally but maybe a guides leader or work for the Brownies or something like that, then a PiPoT won't be made, because the PiPoT can only go on the information that is shared regarding where that individual works. So if people don't make arrangements to understand where that individual may work, there's no point in sharing a PiPoT, because it won't go any further. Also, to be quite explicit on where that individual works. So if you're not in health, for example, people think that health is all under one umbrella and we all know each other and we all work off one system, and it's really not the situation. The same for social care. Just because you work within social care, where do you work in social care? Because as well, when that information is shared with different organisations, it needs to be proportionate. So we're not going to share information about an individual following an allegation or a concern to all the managers that we know in social care. It has to be quite specific. So when you're having your conversations with colleagues, please try to understand where they work, because again, if they're not specific, the information won't be able to be shared, because it can't just be shared far and wide just in case that person works there, or just in case it falls on the desk of an individual that may be a manager within a certain team. And lastly, information sharing and record keeping is essential to safeguarding all. This is about safeguarding people. Again, it's not about pointing fingers. It's not about saying this person is unsuitable. It's about sharing information. So risk assessments can be undertaken to see if that person needs support, what's going on in their lives, or actually whether they need to not be working with adults with care and support needs at that given time. It may be that that isn't a permanent decision. It may mean that there needs further elements of investigation, but it's just about making sure that the reason that we're doing it is to safeguard adults and children. Does anyone have any questions for me? Changus? Are you talking, Changus, because you're on mute?
Thank you, Victoria. Really succinct and to the point presentation. My question is actually, I want to prevent duplications in cases. So, for instance, if there is a nurse and based at NGH, we are then sent a referral to say that this allegation has come forward. The individuals is supporting their family member, and they had actually abused or financially abused the individual. So who would fully lead that? Because they don't want to prevent that duplication, and referral comes to the local authority as well. So where does it fully sit? To, because you have that hospital would have their policies too to prevent the duplication.
So do you mean when the referral was received? Or I'm not sure what you're asking, Changus. Sorry.
NGH comes across information about a nurse who has financially taken advantage of their mother. So where would that whole PiPoT sit with the NGH, or will it come to the local authority to prevent that duplication?
Right. Okay. So it would be within that initial internal investigation. So obviously everyone should have their own processes and procedures following an following an allegation. And at that point, so whether it's a HR investigation, they should be considering and having that conversation with that individual to say, do you work anywhere else? And at that point, they could then refer into PiPoT. It shouldn't just be an expectation that's shared with PiPoT until you've got the facts of where that individual works, if they work anywhere else. Because if they don't, and the risk, so say it's a nurse here at NGH, if the nurse only works here at NGH, the risk is our risk in that respect. So we would manage that risk unless we understood that she worked or he worked elsewhere, then we would share it with PiPoT. But it should be your own internal process. You should start following an allegation made against a staff member, and at that point they should be considering whether a PiPoT's required or not. Does that make sense?
Yes, thank you. That does. And in that, let's go with the same example. What would you share with the local authority if that was the person just employed within the NGH?
So say for example, that nurse worked at St Andrews, which is a mental health hospital across the road, then I would share with the local authority on the PiPoT form that this individual works elsewhere, and they would then review that information and think, is there enough risk to share with the lead at St Andrews? So they're sort of the middle man in that respect to then share the information.
Thank you.
No worries. Any other questions? I'll take the silence as a no. If you do think of any other questions, then you can always contact me, or you can contact Chloe, who can forward the question on to me. I hope you enjoyed the session.